Learned counsel for the petitioner, while opening the arguments, contends that Election Commission of Pakistan has no jurisdiction to challenge or question the internal appointment of official of PTI or set aside intra-party election held and declare them void. Therefore, the impugned order is not sustainable in the eye of law, as the ECP is not a court of law, that no such jurisdiction has been given onto ECP under the Constitution and the Act. Therefore, such jurisdiction to interfere with intra-party affair would be contrary to the freedom of association. Hence, Section 215 of the Act be declared ultra vires of the Constitution, that the impugned order. It is further submitted that the provision of ordinance are very much clear that remedy of filing of criminal complaint under Section 20 of the ordinance is dependent upon non-fulfillment of obligations with respect to finance facility and use of word judgment in Section 3 of the ordinance means that unless default is determined, the criminal proceedings cannot be initiated. In course of arguments has repeatedly relied upon the judgment. Full stop. Learned counsel for the petitioners has further made reference to case. On the other hand, learned counsel for financial institution has relied on case, and he has stated that merely for the reason that civil suit is filed. According to this statement, a murderous attack by firing was made on the complainant on 17th of January 1972 at Kasur, and a case about that occurrence was registered in police station city Kasur. Full stop. Another attack was launched on the complainant on the 24th August 1974 in Islamabad by automatic weapons. Full stop. A detailed report of this occurrence was given in the police station Islamabad. Full stop. On the 9th November 1974, the complainant received information from Muhammad Hanif, electrician, Tubewell, Model Town City, that a day earlier 4 to 5 persons were in search of him and were making inquiries about the location of his house. Full stop. At about 12:30 a.m. Start. Police have a statutory duty to investigate the circumstances of the alleged cognizable offense. The case stated that the police do not require any judicial authorization for this purpose. Full stop. The court's inherent jurisdiction cannot undermine this statutory authority. Full stop. The roles of the judiciary and the police are distinct yet complementary, with the balance of individual liberty and law enforcement achieved by following each institution to fulfill its designated functions. Full stop. However, the court retains the prerogative to intervene under section to give direction in the nature of habeas corpus in appropriate case. Full stop. Brief facts of these appeals are that appellant plaintiff was BSc student of the University of Agricultural. Full stop. Faisalabad, enrolled in 5th semester in the year. Full stop. The appellant experienced pain in her arm. Thus, she along with her father went to Allied Hospital for medical checkup. Full stop. After radiography, the appellant was diagnosed with cervical rib disease, and professor referred to as respondent, an orthopedic surgeon of the said hospital advised for immediate surgery, and on the same day the appellant was admitted in the hospital. If it is accepted as held by the Honorable Judge, what would happen if such number is 5 or more, as in such a situation the protection provided by section of the act would be down even below the level of rupees 1000, which was the limit provided before the recent amendment made, and would be highly insufficient for survival of any individual. Full stop. In my view, the legislature wide said amendment has desired to increase the earlier limit of rupees 1000 to rupees 5000 per head, and has not fixed it as a whole for all those who have such right against one person. The rejection was occasioned by the fact that upon examination of the voter certificate of the proposer, one his name was found not to exist on the electoral roll as a registered voter for the said constituency. Full stop. Upon this finding of fact, the returning officer proceeded to reject the nomination papers. Full stop. Learned counsel for appellant has candidly admitted that the proposer of appellant no longer figured on the electoral roll of registered voters. Start. Suit was registered by the respondents on multiple grounds through a written statement. Full stop. On account of serious challenge on both sides as reflected in their respective pleadings, the trial court proceeded to frame multiple issues. Full stop. After framing of issues, both the sides produced their evidence, and upon completion of the same, suit was decreed wide judgment dated December. Full stop. Feeling agree, the respondent preferred an appeal before the district judge. Full stop. The appeal was ultimately allowed by way of diffuse judgment and degree. Full stop. Start. Section 6 of the ordinance places a restriction on the second marriage of husband the unless he obtains prior permission in writing of the arbitration council. Full stop. Subsection 5 of section 6 of the ordinance provide consequences of contracting second marriage by a man without permission of arbitration council, one of which is that he has to face prosecution in complaint, and if it is proved that he contracted second marriage without permission of the arbitration council, he shall be liable to be convicted and punishable with the simple imprisonment which may extend to 1 year and with fine of 500,000 rupees. It seems that these provisions are concerning the single account and do not say anything regarding joint account. Full stop. It is not understandable that when amounts are with the post office, how the interest on the same can be denied, especially when the survivor is still alive, depositing the amount and operating the account. Full stop. So far as reference of the post office saving bank rules is concerned, the said provision says that profit on the account of a deceased depositor comes to an end with his death, in as much as profit is not given on money deposited in the account of a deceased depositor after his death. Again, so far as first ground for the rejection of appellant's nomination papers is concerned, it is the stance of appellant that during, according to final delimitation report, the name of his proposer was reflecting as a voter member of constituency, but thereafter, while issuing revised final delimitation report, his name was excluded from the voter list of his constituency with malafide. Full stop. In this regard, I have observed that The revised delimitation report was issued by the Election Commission of Pakistan prior to the submission of nomination papers. Full stop. Besides, it is an admitted position in this case that nobody, including the appellant,